Good morning. We're going to look at a new video clip this morning, continuing with our discussion of Katz and Jones. We're going to look at the application of Katz and Jones uh, to the question of what is a search. The first place we're going to begin with is open fields. In Oliver versus U.S., they dealt with an open field doctrine and whether open fields was subject to the Fourth Amendment. The principle found in Oliver versus U.S. is that if the government has if the public has access, then the state will have access also. If the public has access, the state would have access also. Basically, what the court said is that open field is an unprotected area left open to the public. The Katz principle doesn't apply because there is no subjective expectation of privacy. The area is left open to public view. If it's left open to public view, then the government will have access to. Open fields do not provide the setting for those intimate activities that the Fourth Amendment is intended to protect. That is, the Fourth Amendment is meant to protect intimate activities from government oversight. And thus, if it does not provide that particular protection, that is, open areas or unprotected areas or what is considered to be an open field, it is not going to be controlled or is not going to fall within the purview of the Fourth Amendment. The Fourth Amendment does not apply to open fields. Why? Because the public has access. That was a big question in Oliver versus the United States, and that is the fact that there was a trespass rule. There was trespass signs. It has no trespass. And the general rule or the basic thought is that public would not trespass on the property where the person has asked you not to trespass. It's a no trespass sign. That it violates a common law. The court dismissed that argument. The court said that the law of trespass forbids intrusion upon land that the Fourth Amendment would not proscribe. But trespass law extends to instances where the exercise of the right to exclude vindicates no legitimate privacy interest. Thus, in the case of open fields, the general rights of public protected by the common law of trespass have little or no relevance to applicability of the Fourth Amendment. No society values are meant to be protected by the Fourth Amendment are offended, or societal values that are meant to be protected by the Fourth Amendment are not offended. That is, an open field is an unprotected area. It is not within the purview of the Fourth Amendment, and therefore the open fields receive no protection under the Fourth Amendment. Next, the court looked at the curtilage. The curtilage is that area that's immediately surrounding the home. My porch, my yard, my garage, my carport, those areas that immediately surround the home. It is the area to which extend the intimate activities associated with the sanctity of a man's home and the privacies of life, and therefore has been considered a part of the home itself for the Fourth Amendment purposes. One of the things that we have to talk about here when we talk about the curtilage, we must revert back and talk about the home. The home is considered the first among equals. If you remember, in the Fourth Amendment, we mentioned that the Fourth Amendment protects people, houses, persons, and effects. That home gets the greatest degree of protection under the Fourth Amendment, even more so than your person. The home gets the greatest degree of protection. And so we want to protect that area that's immediately surrounding the home also. That area that extends to intimate activities that are associated with the home. And therefore, that curtilage is what it's called, will be protected. It will be protected. But there are limited protections on the curtilage, and we're going to talk about that in a little bit. There are four factors that Dunn gave us when we look at whether that area that the person seeks to protect is part of the curtilage. The proximity of the area. How close is the area related to the home? Whether the area is included within enclosures surrounding the home. Is it fenced in? Is there some way that we place borders or boundaries around it to show that this is a part of a home? The nature of the uses to which the area is put. Is the area put to the use that are activities that are associated with the sanctity of a man's home? Or is it used for something else? Is it used for business? Is it used for illegal activity, primarily for illegal activity, primarily for business? Is it associated with those intimate activities that we would say that be a part of a man's home? And the steps taken by the resident protect the area from observation by police passing by. Now, and then from Dunn, what we do is we move on to Florida versus Jordines. Florida versus Jordines really gives us a principle that deals with a physical intrusion onto the curtilage of a person's home. We said the curtilage is that area that's immediately surrounding, the immediate proximity of the home. And thus we're going to give it the same protection of home, a limited protection, similar to the same protection of the home, I should say, because it doesn't actually receive the same protection of the home, the exact same protection of the home. The curtilage, the court in Jordan says the home is at first among equals. The home, a person's home, is at first among equals. It says at the core of the Fourth Amendment, the right of a man to retreat into his house, into his home, and to be free from unreasonable government intrusion. At the very core of the Fourth Amendment is the right of a man, the right of a person to retreat to his or her home, and therefore be free from unreasonable government searches and seizures. The home is the man's castle. It is where the man will go and seek sanctity. It is where the man can believe that he can have peace, and he can, and all government intrusion will be obstructed, except for that which is determined by a warrant, a neutral and attached magistrate. The area surround the home, an area around the home, the curtilage it is intimately linked to the home, both physically and psychologically, and is where privacy expectations are the most heightened. The front porch is a classic example of the curtilage, and that's what happened in Florida versus Jordans. The police officer brought a drug sniffing dog onto the property, and he ended up on the person's front porch. The court said, "Hold it, you've gone too far." That's a classic exemplar of that area that is intimately associated with the home, and the activity of the home extends to that front porch. Officers, they also said, if you look at Jordan's, however, officers do not need to shield their eyes when passing by the home on public thoroughfares. That the officer does not have to shield his eyes. He doesn't have to avert his eyes when he passed by the home. An officer who's jogging down the street sees illegal activity. He doesn't have to avert his eyes to that illegal activity. However, in order for the officers to get into the home, and to that private area that man seeks to keep private, so that's the very core of the Fourth Amendment, there are three things that are needed. There are three things that are required. You must have consent, you must have a warrant, or there must be exigent circumstances. Absent one of those, the government will not be able to get into the person's home. Must have consent, a warrant, or exigent circumstances. And those principles we'll speak on, or we'll talk about as we go through the semester. But an officer does not need to shield his eyes when he's passing by the home on public thoroughfares. Now, does that mean if an officer sees me sitting in my office and he looks through my window as he's jogging down the streets, that he can come into my abode, into my home, and he can, when he sees that I'm sitting in my office and I'm smoking a joint, he obviously sees that it's joint. He sees me roll the joint. He sees it and he smells the scent that's coming because I have my window open, right? And so he smells the scent. Can he come into a home? No, but he doesn't have to avert his eyes. He has enough information to do what? To gain a warrant. Unless there are exigent circumstances to say that if he doesn't have time to get a warrant. He doesn't have time to get a warrant, and therefore he must act immediately. And again, we'll talk about exigent circumstances as we go along in the course. Jordan also says the question, very important, Jordan, the question is whether the homeowner has given leave, explicitly or even implicitly, for the officer to enter the property. That is, whether his interest is licensed physical intrusion, an unlicensed physical intrusion. Whether the officer is given leave, whether he's invited, whether he is given leave, he's given permission to come to the port, to come into the property, and whether whether his entry is an unlicensed physical intrusion. Now, the court went on to talk about this unlicensed or this licensed physical intrusion. It says that certain invitations or license intrusions to enter the person's house, to enter that area that's immediately associated with the home. They're invitations, they're license attempt to enter. It says that, and based upon societal expectations, that typically we expect or we permit a visitor to approach our home by the front porch, to knock on the door promptly, to wait to receive an answer. And then if there's no answer, we expect them to leave, right? And there are certain things that we will expect. The insurance salesperson will come and knock on your door. Girl Scouts will knock on your door. Other peddlers will knock on your door. But they come and they knock, and society expect them to come. Society believe that they will come. And so these are invitations or their license attempt at an entry. A police officer not armed with a warrant may approach a home, and thus there are certain instances where a police officer can approach your home. He will be one of those persons who is licensed or making a license attempt at an entry. A police officer can, not armed with a warrant, approach the home and knock precisely because it is no more than any private citizen might do. It's no more than what a private citizen might do. We expect private citizens to engage in some activity, and if the police officer engages in that particular activity no more than what a private citizen would do, he has made a license approach or an attempt to make a license entry onto the property. By introducing a trained police dog to explore the area around the home and hope of discovering incriminating evidence is something else. There's no customary invitation to do that. Societal expectations, societal norms. Society do not or would not accept or do not accept the police officer enter into your property with a drug trained dog for the purposes of gathering information or information that's going to be incriminating to be used against you in similar future criminal prosecution. And thus, there are two steps to whether this entry onto the property, this physical trespass onto the property, is going to be considered, and the property being your home, being your curtilage, is going to be considered a search. First, is it licensed? Is it something that doesn't shock societal norms? Is it something that we have generally permitted? Is it something that we invite people to do? Is it something that people would do? And so, if it's something that people would do and it falls within societal norms, and not only do it falls within societal norms, the second thing you have to look at is the purpose. What is the purpose? If it does fall within the societal norms, however, the purpose is for to gain and hopes of gain and discovering incriminating evidence that can be used in future prosecution, it is not a licensed intrusion. It's an unlicensed intrusion, and therefore it will be a search. My neighbors don't come onto my property. I do not expect my neighbors to come onto my property for the purposes of gaining information that's going to be used against me for future criminal prosecution. And so it's societal norms according to according according to Jordanes, and the purpose when government physically enters onto your property, that is your home, that is the curtilage of your home. And I'm going to stop there for one moment. Uh, and well, let me go on. Let me cover one more case that deals with that curtilage and deals with that physical intrusion. And that case is Collins versus Virginia. In Collins versus Virginia, police officers had noticed a certain motorcycle, orange motorcycle with a black stripe with a lightning bolt or something on it. It had violated the law on several occasions. It was speeding. It was driving. The person or the driver was speeding when he was driving recklessly. And the police officer got information about this motorcycle off of social media, right? Everybody posted everything. And the police officer went onto the property. He saw what he believed to be the motorcycle. But he went onto the property and he lifted the tarp. And once he lifted the tarp, he found that it was the motorcycle. That the motorcycle was covered with a tarp, I should say. And he lifted the tarp to see the motorcycle, and he found that it was the motorcycle. And he filed for a warrant. He was able to get a warrant. The occupant or the owner says, hold it, you violated my Fourth Amendment right. You've come into my curtilage for the purpose of making a determination as to whether the motorcycle is one that was previously involved in some criminal activity. And therefore, there's a violation of the Fourth, there's a search and there's a violation of the Fourth Amendment, and you did not have a warrant. The only way you can get onto my curtilage, the only way you can get onto my home in that particular situation is that you must have a warrant before you do it, not after you do it, the court said. And the question really became whether the automobile exception extends except beyond the automobile. That it extends to an automobile that was located on the curtilage. Remember, this automobile had been involved in criminal activity, and thus you had probable cause, or the court, or the officer had probable cause for the purposes of believing that the automobile, because he had proof or he had probable cause to believe that automobile was involved in criminal activity. But at the time that he located the automobile, it was not involved in criminal activity. It was sitting on the person of sitting in a person's front yard. That is his curtilage. The court said, nothing in our cases, in our case law, suggests that the automobile exception gives an officer the right to enter a home or its curtilage to access a vehicle without a warrant. Expanding the scope of the automobile exception in this way would both undervalue the core Fourth Amendment protection afforded to the home and its curtilage. It does not matter that the officer had probable cause for the motorcycle. The automobile exception does not precede or does not precede the privileges, or supersede, I should say, the privileges given to the home or the curtilage. It doesn't matter that he had probable cause for the motorcycle. The automobile exception does not supersede the privileges given to the home or the curtilage. The curtilage of a home is given limited protection from government intrusion. If government operates in a legal permissible area where government can gain access, then its conduct is not a search within the Fourth Amendment. Measure how the government obtained access. Was there a trespass? Was the trespass a legal trespass? And what was the purpose of the entry? Was the entry for the purposes of gaining illegal gaining information that's going to be used in future prosecution, incriminating information or evidence that's going to be used in future prosecution. With that, I'm going to stop this video, and we'll pick up there on our next video with the application of Katz. Thank you very much.